I think, talking about a critical issue, and we are really lucky to have former Justice Goldstone here to outline some of the issues related to, or some of the intricacies related to an international anti-corruption court. Today is the 4th of December, and we are kicking off Defend Our Democracy's contribution to Anti-Corruption Week, which officially began yesterday. As many of you would know, the 9th of December is marked as International Anti-Corruption Day. And what's great is that we also then celebrate International Human Rights Day on the 10th. And so this week really gives us good reflection time to think about how corruption impacts human rights, and how it affects people's daily lives, and how it really does negate the vindication of human rights in South Africa and globally. We have with us today former Justice Goldstone, who really doesn't need much of an introduction, but I'm going to give one anyway. So many of you would know that former Justice Goldstone actually started off in his law career, or in his legal career, as a commercial lawyer, but then was appointed by the government to serve on the Transvaal Supreme Court from 1980 to 1989, and then the Appellate Division of the Supreme Court of South Africa from 1990 to 1994. But what Justice Goldstone really describes as the pinnacle point of his career was being appointed to the first bench of the Concord by President Mandela in 1994. His track record, and I'll read it to you, because as I was researching about who he is, I was impressed. And so I'll talk a little bit about those things. He was the chairperson of the board of the Human Rights Institute in South Africa, and he still remains a trustee thereof. He also served as the Chancellor of Wits University from 1995 until 2007. From August of 1994 to September 1996, he served as the Chief Prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda. And he was also a member of the international panel established by the government of Argentina in 1997 to monitor the inquiry into Nazi activities in the Republic since 1938. He's also served as the chairperson of the International Independent Inquiry on Kosovo. And in 2001, he was appointed the co-chairperson of the International Task Force on Terrorism, which was established by the International Bar Association. Of course, here in South Africa, his commitment to justice played a pivotal role in ensuring and contributing toward the peaceful transition toward a democratic country. He has a remarkable career, which is clear, that spans over 4 decades. And his unwavering commitment to human rights has earned him international recognition and claim. For the purposes of today, Judge Goldstone also serves as the Vice Chairperson on the Integrity Initiatives International, which is a global NGO that is leading the campaign to set up the International Anti-Corruption Court. And so he is really at the center of the idea and of advocating for an international anti-corruption court. And we are excited to hear from you, Justice Goldstone. What we will do is former Justice Goldstone will give a contribution for around 20 to 30 minutes, and then we'll open it to all of you to ask any questions. So over to you.
So, thank you very much, Kirsten, and thank you to Defend Our Democracy for inviting me to join you this evening to talk about the project to set up an international anti-corruption court. I've had very good questions from the organizers from Defend Our Democracy, and I'm going to base my remarks on those questions which have been put to me. The first is, what call is there for an international anti-corruption court? And let me begin by explaining the context in which this arises. In developing countries, it has been conservatively estimated that over 10 times more money is lost to illicit financial flows than is received in foreign aid, which is quite a startling thought. As long ago as 2013, the then United Nations High Commissioner for Human Rights, Navi Pillay, said the following. She said, "Corruption kills. The money stolen through corruption every year is enough to feed the world's hungry 80 times over. Corruption denies them the right to food and, in some cases, their right to life." Since she said that 10 years ago, the amounts lost to corruption have risen very sharply. It must thus be recognized that grand corruption by heads of state and other senior state officials, is very much a human rights issue. Grand corruption, kleptocracy as it's also called, also contributes to climate change and is a major impediment to ameliorating it. As an example, kleptocrats profit greatly from the illicit forestry trade, which is estimated to be worth in excess of $100 billion annually, and likely much more. The primary recipients of government climate-related development include countries that are perceived as being among some of the most corrupt in the world. Unless something significant is done to deter grand corruption, a large percentage of the billions of dollars in aid intended to diminish climate change will be misappropriated by kleptocrats and those who collaborate with them. As we speak, some 70,000 people have gathered in the United Arab Emirates and Dubai to discuss this issue of climate change at COP28. And it is well in this context to recognize that grand corruption is also a climate change issue, human rights issue, climate change issue. The legions of refugees who are overwhelming countries in the Americas and Europe have been fleeing failed states ruled by kleptocrats. These include Syria, Venezuela, and South Sudan. Any effort to alleviate the world's refugee crises must therefore address a fundamental cause of forced migration, grand corruption. So we see that corruption is thus also a refugee issue. Excuse me. The Pandora Papers, published in 2021 by the International Consortium of Investigative Journalists, the ICIJ, provide additional compelling evidence that corrupt leaders throughout the world, aided and abetted by domestic and international accomplices, enrich themselves at the expense of the health and welfare of their often desperate citizens. It's the poorest of the poor who suffer from grand corruption. Those kleptocrats secretly use the international banking system to move their substantial ill-gotten gains to foreign countries. The Pandora Papers exposed the secret finances and lavish styles of more than 330 politicians, including 35 then current and former heads of state. I should hasten to add that many of them did not relate to ill-gotten funds, but at the same time, many did. The Pandora Papers followed the ICIJ's Panama and Paradise Papers, which provided similar evidence of grand corruption. Because grand corruption pollutes the international financial system and has other severe international consequences, it is not just a domestic problem for individual countries to address alone. It is really a global problem that requires a global solution. I would add that grand corruption does not exist because of a lack of anti-corruption laws. Far from it. There are 185 member states to the United Nations Convention Against Corruption, UNCAC. Those 185 UN nations, and it's almost all the membership of the United Nations, 185 out of 193 states, most of them have enacted the required statutes criminalizing bribery, money laundering, and the misappropriation of national resources. However, some states that are party to UNCAC are governed by kleptocrats who enjoy impunity in the countries they rule because they have taken control of the police, of prosecutors, and the courts. Some of those authorities are often also corrupt themselves. Those kleptocrats will not permit honest, effective investigation of themselves or their criminal corrupt collaborators. And we must not forget the criminal co-conspirators around the world, the banks, the law firms, real estate agencies, and other financial service providers who aid and abet kleptocrats in the transnational crime of money laundering. So that is the context, the broad context in which there is a developing effort to establish the International Anti-Corruption Court. The next question is, why is this important for South Africa? And that really speaks for itself. In South Africa, we refer to grand corruption rather quaintly as state capture. We all know the investigations and recommendations made by the Zondo Commission. And I need hardly add that all South Africans are suffering from the consequences of that corruption. The woes of Eskom, our daily load shedding, as again we quaintly call it, our broken railways, South African Airways, our hopelessly inefficient ports. There's consequential huge unemployment. Just about every state-owned enterprise has been almost destroyed because of greedy state officials and some private citizens who have plundered them. Adding to our woes, we have a legislature and executive that are less than diligent in implementing most of the sensible recommendations made by Chief Justice Zondo. And the corruption continues. We read reports of recurring theft of public monies each day, just about, and they dominate the news. Our prosecuting authorities continue to battle in the face of insufficient resources, both human resources and financial resources. And the Gupta brothers continue to evade arrest and continue to have access to their illicit billions of stolen dollars. So what is to be done? As a vice chairperson of Integrity Initiatives International, or as we call it, III, I'm an ardent advocate for the creation of an international anti-corruption court, the IACC. Such a court would hold kleptocrats, the highest state officials, and those who collude with them, accountable where national authorities are unable or unwilling to do so. The scarce resources that would be available to this court will necessitate that its jurisdiction be limited to grand corruption, to kleptocracy, the plunder and stealth of public assets by heads of state and other high officials. The envisioned International Anti-Corruption Court would have jurisdiction over crimes committed by nationals of an IACC member state and crimes committed in the territory of an IACC member state. The IACC would not have any need to invent any new crimes of corruption. It would rely on those crimes already recognized, as I've mentioned, by the 185 states that have ratified UNCAC, the United Nations Convention. Those crimes have really become internationalized. They include the bribery of public officials, embezzlement and other misappropriation of public funds, money laundering, and the obstruction of justice in relation to those offences. The IACC would be a court of last resort. This means that it would acquire jurisdiction only in cases in which the appropriate domestic authorities are unable or unwilling to investigate or prosecute the corruption. Member states would also be able to refer cases to the IACC. So it would operate on the basis of a system of complementarity, as it's called, which applies also to the International Criminal Court. It would be an institution able to offer what could be crucial assistance, for example, to states that are willing to investigate and prosecute the corrupt, but do not have the resources to do so on their own. The IACC's expert investigators and prosecutors could be called upon for assistance by prosecuting authorities in such countries. At least one such transitional country in Europe has already endorsed the establishment of the IACC. The court's personnel could work with nascent islands of integrity in such a country to help build its cases. That could include facilitating mutual legal assistance requests that are required to obtain evidence located in foreign jurisdictions. If the judiciary of such a country is independent and able to preside over cases brought by anti-corruption prosecutors, then the role of the IACC would stop at providing such assistance. If such a state were, however, to determine that its courts are still too corrupt to properly adjudicate cases of grand corruption, then they could refer the cases to be heard by IACC judges. In this scenario, it would be preferable for the IACC judges to travel to the country concerned or to a nearby regional country for the trials. In that way, justice could be conducted as close to home as possible. That would make the proceedings more accessible to victims, civil society, and the media. If South Africa were to join such a court, it would have jurisdiction over the high state officials involved in corruption and could exercise that jurisdiction if our own prosecuting authority is unable or unwilling to do so. The IACC could assist our own investigators and our own prosecutors in bringing the senior instigators of grand corruption to court. It could also assist in following the illicit assets to countries where they have been laundered. Very, very important issue. The following up and repossessing the millions, if not trillions, of dollars that are laundered overseas. And our authorities, unfortunately, have been singularly unsuccessful in doing so. Some people ask, and I'm often asked the question, is the solution not to use the International Criminal Court? After all, the court is up and running. Why establish another international court? Unfortunately, there are insurmountable obstacles to this suggested solution. In the first place, the Rome Statute for the ICC does not recognize crimes relating to corruption. It would have to be amended, and that is a time-consuming process. It would take probably 10 or more years to achieve that. And in the end, it requires the agreement of 7/8 of the 123 countries that have presently ratified the Rome Statute. Achieving that support is highly unlikely. In the second place, the ICC does not have the expertise to manage crimes of corruption. It does not have expert judges, expert investigators, expert prosecutors with necessary expertise and experience in cases of serious fraud. That obviously would be essential if crimes of corruption were to be added to the jurisdiction of the International Criminal Court. And thirdly and finally, the resources of the ICC are very limited, and a chief prosecutor of the ICC would have serious problems in giving priority to crimes of corruption above some of the worst atrocity crimes that are brought before that court. The next question is, how will the IACC help prevent impunity for leaders implicated in corruption? Now, of course, we must recognize that kleptocrats, these dishonest state leaders, will not allow their countries to join an international anti-corruption court. Indeed, they will do everything in their power to hamper investigations into their own criminality. However, they have an Achilles heel, a crucial weakness, and that is their laundered illicit funds. For obvious reasons, few, if any, kleptocrats keep their ill-gotten gains at home. It is too risky. Billions of dollars of stolen assets have been laundered in a number of countries. They include the United Arab Emirates, the Netherlands, Singapore, Switzerland, the United States, the United Kingdom and its overseas territories, the Cayman Islands, and there are others. If some of the countries where laundered funds are held would join an international anti-corruption court, and several are considering doing so, then illicit assets could be identified and frozen by the court. Through orders of restitution, those funds could be repatriated to the countries from which they are stolen. If there's a high risk of those funds being misused, if returned to a corrupted state, they could be repurposed for refugee and humanitarian purposes, or repatriated only at a time when they would reach the real victims, the millions of poor people in need in those countries and their forced diasporas. Drafting a model treaty for the International Anti-Corruption Court, III, Integrity Initiatives International, is presently very busy drafting a model treaty for the establishment of the IACC. We are learning many lessons from the former and existing international criminal courts, and especially the ICC. We have concluded, for example, that the IACC would not require a system of pre-trial chambers. In the case of the ICC, the International Criminal Court, pre-trial chambers have proved to be an expensive and time-consuming process. They were not a feature of other successful international criminal courts, including, for example, the United Nations International Criminal Tribunal for the former Yugoslavia or the one for Rwanda. There are other ways, too, in which an IACC could be more cost-effective than the ICC, including only employing a small number of permanent judges. Other vetted and approved judges would be called upon only when the caseload requires their services. But regardless, the operational cost of the IACC would constitute a small fraction of the amount of illicit assets that it could seize and return to their originally intended purpose, the public good. In addition to orders of restitution, it could levy fines on those found guilty, and these could be used to defray some of the costs. Another innovation we are considering is having a two-chamber court. There would be a criminal chamber and a civil chamber. The criminal chamber would have jurisdiction over kleptocrats and other high officials who have plundered their countries and those complicit with them. The other chamber would be a civil chamber that would have authority to freeze and seize the laundered stolen assets and hold them until they can be returned to the real owners, the people of the countries who have been robbed. The civil chamber could also resolve inevitable disputes that are likely to arise with regard to identifying the laundered funds and determining their fate. Our drafting committee, that's the drafting committee of III, has been discussing other important and interesting issues. Time does really not permit me to go into them, but I would mention two of them in passing: head of state immunity and the role of victims. Head of state immunity is important. The question as to whether the court would have jurisdiction over heads of state. And that's not an easy question, but there are aspects of the proposed IACC, including the universal nature of the crimes that it would have within its jurisdiction, that would make it likely that it would be regarded as an international court for the purposes of having jurisdiction over heads of state. With regard to victims, in the case of the International Criminal Court, there are many victims of the crimes that are committed, whether it's enforced pregnancies, enforced prostitution, some of the other terrible gender-related crimes that are committed, crimes against humanity, genocide. In the case of the International Anti-Corruption Court, in the case of kleptocracy, grand corruption, the victims are really all the citizens, all of the nationals of the country concerned. And I think some of the problems that have bedeviled the courts, that have made the judges really work very hard in the International Criminal Court, and that is dealing with the registration of victims and giving victims the right to representation, would not really be relevant for the International Anti-Corruption Court, where, as I say, the victims are inevitably going to be all of the citizens of the country concerned. If they're discrete victims of any crimes of corruption, of course, the court will have to recognize that and recognize the rights of those victims. What will the IACC mean for transitional business offenders, such as the Guptas, for example? An IACC would be able swiftly, really swiftly, to freeze laundered assets in countries that have joined the courts. There are governments who are not necessarily aware that illicit funds have been laundered in their countries. It's not done openly. Some of those countries do not approve of these activities involving their banks, lawyers, and property markets. They are presently considering favorably the idea of the IACC. In Switzerland, the United Kingdom, Singapore, and even the the UAE were to join the court, the illicit funds that have found their way into those countries would become available for freezing and forfeiture. How would cases be lodged with the IACC? Well, cases will be lodged by states and by members of civil society. In this regard, I would emphasize the role of whistleblowers. Cannot be overemphasized. In this context, I again refer to reports released by the International Consortium of International Journalists, Pandora Papers, the Panama Papers, and the Paradise Papers. Civil society organizations are playing ever-increasing roles with regard to international justice. Their voices are being heard ever more frequently on the laws that are being adopted and the cases that are being brought to international courts. In the case of the ICC, there are many hundreds of civil society organizations who are consulted by the governments and officials who are responsible for the proceedings of the court. That would no doubt be the case in respect of the International Anti-Corruption Court. Who would hear the cases, and what punitive measures could the court impose? Well, the judges would be appointed by the states that join the court, and they would have to be required to have appropriate experience with regard to financial fraud and money laundering. So too, the prosecutors and investigators would have to have experience in those fields. Those found guilty by the IACC could be sentenced to long terms of imprisonment, to pay heavy fines, and importantly, to suffer the forfeiture of their illicit assets. Will such a court be effective, is the question asked. The effectiveness of the IACC will depend to the greatest extent on the countries that join it. I repeat that it would be essential for countries in which illicit funds are habitually laundered to become members of the court. It would also be effective if developing countries that lack human and financial resources to properly investigate grand corruption join the court and benefit from assistance to their courts from the experienced staff of the IACC. Will nations readily agree to be part of the IACC, given that it would mean relinquish some of their own sovereign power and decision-making? Well, in today's complex and interdependent world, there are no governments, there are no countries that have not ceded sovereign powers and decision-making powers to international institutions and authorities. If governments are serious about combating grand corruption, they would not find it difficult to cede some of their sovereignty to effectively combat the loss of billions of dollars by way of grand corruption, clearly in their interest to do so. So too, many of the countries that are the unwilling or unwitting recipients of illicit funds, they would be likely prepared to relinquish some of their powers in order to achieve an efficient and effective IACC. Then I'm asked whether the International Anti-Corruption Court would be accused, like the ICC, of only holding African and Eastern European leaders accountable, while Western leaders are allowed to act with impunity. Would African states in particular agree to the idea of an International Anti-Corruption Court, given this track record? Well, let me give an assurance that no efforts are being spared by III to ensure that the IACC will be representative of the whole global community. If it is, whether in fact or even perception, regarded as a Western or global North institution, it will fail, it will not succeed in accomplishing its mission. Grand corruption is truly an international problem and has to be tackled accordingly. At the end of August of this year, III organized the first in-person expert group meeting for the IACC Model Treaty Drafting Project. It was hosted in Hamburg, Germany by the New Institute. The jurists, lawyers, scholars, and anti-corruption experts who came to that meeting hailed from Trinidad and Tobago, Nigeria, Brazil, Cameroon, Bangladesh, and Mexico, as well as the United States, Canada, Australia, and New Zealand. We are presently taking steps to encourage more jurists from civil law systems to join us in drafting the model treaty. III has established an African subcommittee that meets every month, being co-chaired by Coogan Pillay, a leading South African crusader for justice and accountability, and Landray Saraju, a courageous anti-corruption activist from Nigeria who runs the Hedda Resource Center. The committee's members include leaders of some of the African chapters of Transparency International, and we have a growing group of young supporters from a number of countries around the world, including from Africa. There are now over 300 leading figures from across the world, including Africa, and including more than 50 presidents and prime ministers and 32 Nobel laureates who have signed a declaration calling for the creation of the IACC. Colombia was the first country to call for an IACC back in 2016. More recently, the Netherlands, Canada, Nigeria, Moldova, and Ecuador have committed to working towards the creation of the court. In January of this year, the European Parliament passed a resolution calling for the International Anti-Corruption Court. Additional countries from each region of the world have also expressed their interest in looking at the idea. The United Kingdom Labour Party announced in July that it will champion the IACC idea, and there is further cross-party support for the court in the UK. Apart from Nigeria, there is strong interest from governments in Senegal, Zambia, and Côte d'Ivoire. It is important that South Africa should be added to this list of interested African governments. So there is substantial civil society interest in the IACC from across our African continent. Let me end by saying that the effort to create the IACC will take time, but the momentum generated in the past 2 years suggests that it may be possible sooner rather than later to establish such a court. The time is right now to therefore strengthen the proposal so that the eventual court can provide as meaningful as possible a check on corruption. I thank you.
Thank you very much, Judge Goldstone. I just want to be sure that I'm also being seen. I think thank you first for framing the discussion in terms of the human rights violations that you've outlined. So related to food and hunger and poverty, also related to climate change, and then related to refugees. I think that's always what we need to be drawing linkages to, how literally corruption kills. And that's outside of the scope also of whistleblowers who have lost their lives, both here in the country and globally. And I think human rights defenders generally, journalists, civil society actors, or who are advocating against corruption and really are sacrificing in that way. There are a couple of comments on the chat, and I'm going to open for a round of questions in a minute. I think maybe what to do is I'd like to just outline some of the concerns that are coming up around the chat, and then perhaps maybe frame it in terms of a question for you to answer, and then we'll give people an opportunity to ask some more questions. So I think one of the sentiments being expressed is that we have great corruption levels in the country, and so why should we be focusing at an international level and not locally? And I think one of perhaps the ideas being expressed there is that we'd be then partaking in prosecuting corrupt individuals instead of focusing on corruption within our own country. And so maybe just for you to clarify, and I've heard you say this a few times, that the IACC would really serve as a tool for assisting South African courts where they are ill-equipped or under-resourced to be able to prosecute those cases themselves. I'm wondering, just from the comments on the chat, because what I was thinking about while you were saying that is that if, and maybe you can elaborate on who would make this determination, but if a country has to make the determination that their courts are actually unable to prosecute corruption cases at the level that is necessary, or like you said, if the courts still remain captured, once that determination is made, one of the anxieties expressed by countries that this would have a really negative look for the credibility of its own judiciary. And what are the sort of effects that would have for prosecuting crime and corruption at a local level?
Well, I think what's important to recognize, Kristen, is that a country like South Africa needs assistance in chasing the corrupt. As I've mentioned, recovering the billions of trillions of South African rands that have been laundered in overseas countries. Some of it certainly is being chased, but a very small proportion. And there are experts in many countries, expertise in many countries that we simply don't have. if there was an international anti-corruption court and South Africa were to join it, it's not a question of South Africa handing over those cases, because South Africa would be willing to do it itself. But that court, by its statute, and this will certainly be incorporated in the model statute that we're looking at, the court will be able to lend assistance, important assistance, to South African prosecutors and investigators in chasing those funds. And for example, certainly if a country like the United Kingdom and Switzerland, I mean, those countries are simply full of laundered monies. And neither Switzerland nor the United Kingdom, and some states in the United States, and there are many of the other countries I've referred to, that provide a home to illicit funds, and an international criminal court would have the expertise to help any country that would need it in following up those assets. So it's very selfish, for very selfish reasons. I don't believe countries act really out of interests that are not selfish interests. It's got to be in the interest of South Africa to join such a court. It's got to be the interest of Switzerland or the United Kingdom to join such a court. But they're considering it because they see benefits for their own system and for their own countries.
Yeah, thank you, Justice Goldstone. And I think it's relevant that we are having this conversation now, which is really a discussion on an idea being put forward at the moment, because we've seen recently with the Coco case that recently came before the court, the unpreparedness of the state in prosecuting these types of corruption cases. Similarly, with the corruption cases against Sandile Gumede, Vincent Smith, we are seeing that there seems to be a lack of preparedness and ability on the state's part to prosecute these cases, and obviously so because of the way in which the prosecuting authority within the country was hollowed out. I maybe just want to follow that up with a question about who in the state itself, if it was a member state and part of the treaty, who in that state would make the sort of determination of referring cases? I know you said civil society actors, but would it be a process of once the state is signed up or becomes a member state, that anybody within the state can refer cases to the court? Or would there have to be a determination that our judiciary cannot handle the task at the moment and all cases go there, for instance?
No, well, certainly, Kristen, the International Anti-Corruption Court would be a court of last resort, similar to the International Criminal Court. It wouldn't have the right to get involved in domestic investigations and prosecutions if the courts of the country concerned were willing and able to do it themselves. If they're not able to do so, then the court may well have jurisdiction. And a country like South Africa, I think, is able to do so, and I think it would benefit very much from assistance from the sort of expertise that's available out there in many countries that we don't have ourselves. And I think we're seeing, as you say, the NPA was hollowed out by state capture, and I think they're battling very hard to get their act together, and I'm not suggesting for a moment that they're unwilling or unable completely to succeed, but certainly it would be in their interest to rely on the expertise that would be on offer from an international anti-corruption court.
Thanks, Justice. And maybe I can ask and take advantage of my position here, just for one last follow-up question, which is that I heard you talking about the seizing of assets where there has been illicit money flows and money laundering, and so when that money is held in other countries. Am I correct in saying that a country would have to be a member of the treaty in order for those assets within that country to be frozen?
No, not really. I see. The country where the assets are to be frozen would have to be a member, certainly.
Okay. Okay.
So if monies are laundered in say a country like Switzerland or the United Arab Emirates, they would have to be members for the court to seize the assets in their country. But those assets could be seized even though the people who did the corruption or don't come from countries that are members of the court.
Thank you. I think that's clear. I think maybe let me open up for some questions from attendees. I see Rolf Pretorius has posted one in the chat. So I'll ask that question, and then if anyone else has a question, perhaps you can just raise your hand and then I'll give you an opportunity to unmute, or you can post your question in the chat. So the question from Rolf is, I want to ask, is such an international anti-corruption court, how would it relate to the international principle of the sovereignty of nations?
Well, of course, the sovereignty of nations is the basis of our whole international system. The sovereignty of nations is enshrined as one of the probably the most fundamental principles of the Charter of the United Nations. But countries every day give up some of their sovereignty. I mean, South Africa gives up some of its sovereignty by allowing foreign airlines to fly over our airspace. That's giving up sovereignty. And why do we do it? Because we want the same right. When our aircraft fly abroad, they also have to rely on the International Civil Aviation Convention, which allows for that. Take simple things that we take for granted, like postal communication. Somebody in Russia wants to mail a letter to somebody in Cape Town. The international postal authorities will do it, and that's countries are giving up some of their sovereignty to do that. Whether it's civil aviation, shipping laws, the international banking systems, the World Health Organization. All of these countries, when countries join them, give up some of their sovereignty because it's in their interest to do so. So again, I think we must be practical, and the politics is important. If the politics doesn't work, it's not going to happen. Without the right politics and without political support, there wouldn't be any international courts in the world. The International Court of Justice, the highest court of the United Nations, couldn't operate if governments didn't join in. And it's interesting that in the case of the International Court of Justice, it has no jurisdiction over any country that doesn't agree for the purpose of a particular case to join in. So it's a question of one hand washing the other, but I think we must be practical and recognize the politics that is essential and that lies behind it.
And perhaps as a follow-up question to that, I know you spoke about the model treaty being drafted at the moment. Would you be able to, elaborate on some of the timelines that are being looked at in terms of when that treaty would be ready? Of course, there's a lot, as you've mentioned, background work going into the advocacy around it. But right. Is there some sort of timeline around when that treaty would be ready and almost presented to states?
Well, I must say, we had a good kick-off session in Hamburg. It's interesting, this new institute is a fairly new foundation that was set up in Hamburg by a shipping magnate who lives in Hamburg. And they heard about the project to set up the International Anti-Corruption Court, and they very generously offered to host us at their wonderful conference center in Hamburg. So that enabled us to have our first in-person meeting at the end of August of this year. And they've invited us to return in April and July of next year, 2024. So our hope is to have a final draft available in the second half of next year. And let me emphasize, Kristen, that this is very much a draft model treaty. It could be up to governments to have to determine it, not up to what we do is really trying to be as helpful as possible and to facilitate the job of governments in coming to agree on a treaty for the International Anti-Corruption Court. And we're producing this draft mainly at the request of governments such as the Netherlands and Canada.
There are a couple more questions in the chat. The one is from Moira, who says, there are many corruption cases that are fueled by large multinational companies. So there is sometimes an international component, and she gives examples of Bain and McKinsey. She asks, can you comment on how big multinationals can be held accountable at an IACC?
Well, it's exactly the same with any individuals. If any large corporation operates, has its head office or any of its operations in a country that joins, they would be subject to the jurisdiction of the court. If their assets are in countries that join the court, their directors would become liable to the jurisdiction of the court. And let me say, in the modern world, to create jurisdiction in countries is facilitated by modern methods of communication. For example, the SWIFT system, if people use United States dollars, it goes through the SWIFT system. And if the United States were to join, any country that used US dollars would be subject to the jurisdiction of the court. So I think if I was a kleptocrat, I think I would be nervous for good reason about an international anti-corruption court being set up.
The next question is, let's do this one. What are some feasible and efficient mitigation acts that civil society can embark on besides being whistleblowers or involving the court of law?
Well, certainly, as I've already mentioned in my opening remarks, civil society plays a crucial role. I mean, in the area of corruption, it's whistleblowers who are the first line, and that's why they're so vulnerable, and that's why they need protection and assistance. And certainly, I'm in favor too of having a financial advantage offered to whistleblowers. There's no reason, in my view, why whistleblowers shouldn't benefit in respect of assets that are recovered as a result of an international anti-corruption court, or in the case of domestic situation, and the International Commission of Investigative Journalists is a civil society organization. But look what it's produced in getting access to these millions of pages of documents showing the extent of corruption in so many countries of the world.
I think there is one more question from Louise, and I'll get to that in a minute. Maybe just as a follow-up question to your previous answer. I heard you mention, and now again, that one of the remedies, for instance, coming from the IACC would be that any illicit funds could be repatriated back to the country. And if there are fears around those funds are not being spent properly, then they could be, I think you said, sort of given, yes, repurposed. I just want to ask about, are those remedies being included in the model treaty or in the model for the IACC? And could you talk about some of the other remedies that may be available through that?
Absolutely. And this is why I think it's an exciting idea that actually came out of Canada, that we should have a civil chamber in addition to a criminal chamber. The criminal chamber will deal with the kleptocrats, with heads of state and senior state officials. But the civil chamber would really play a very important role in relation to the illicit funds, the laundered monies. It's a civil chamber that would have to determine disputes. I mean, a country might dispute that a particular fund comes from corruption. It may have been repurposed, and there may be valid arguments as to why those funds shouldn't be seized by the International Anti-Corruption Court. And the civil chamber would be there to determine those disputes. They would often be disputes between governments. I mean, take as a hypothetical that South Africa doesn't join the IACC, but say the United Kingdom does. Well, there might be properties in the wealthy areas of London that have been purchased with illicit funds, and there's a lot of that, as we know, in cities like London, and there are many cities around the world where shell companies use illicit funds to purchase very expensive properties.
Yeah.
Well, if the International Criminal Court wants to attach, at the instance of any particular country that has jurisdiction, wants to attach those assets in the UK, for example, there might be interest. There might be people in the UK who say no. This is not an illicit funding situation. So a civil chamber of the International Anti-Corruption Court could deal with that. The country where the money comes from, say Nigeria, joins the court. Nigeria might say, we want this money sent back to Nigeria. There may be people in Nigeria who say, no, if it comes back to Nigeria, it's going to again be used for illicit purpose. And I'm using this really as a hypothetical. I'm not suggesting for Nigeria you can add any country you like. But I think there would be a very important and busy role for a civil chamber of an international anti-corruption court.
Yeah, I think those are absolutely interesting remedies. I'm looking forward to learning more about those in particular. There's one last question, Judge Goldstone. I know you said you have load shedding at 8, so let me try to get to this, and then you could possibly just give like a closing comment after answering this question. Louise says there's emphasis on the court, but it seems that countries needing support would need huge investigation capacity, amongst other skills and resources, including relationships with countries' own police and security apparatus. Please expand on this.
Well, a country that has adequate police and adequate investigators and adequate prosecutors wouldn't need the International Anti-Corruption Court. I mean, if you look at a country like the United States, it's got really a very efficient anti-fraud system. It's got very sophisticated statutes that deal with anti-corruption, and so the United States wouldn't need assistance. It could give assistance certainly, but it wouldn't for that purpose need to join the International Anti-Corruption Court. It might want to join the court because it might want to seize assets in a number of countries, a number of other countries that join. So you know, it's really a question. One would have to look at each country separately. And really, to get back to South Africa, I think we sort of in a grey area. The NPA is certainly willing to follow the fruits of corruption and to charge people who are suspected of being responsible for the corruption. It's a question of ability, and that's why I stress that a hugely important role of the International Anti-Corruption Court would be to assist a country like South Africa in following assets in particular, and helping in extradition applications and tracing people. I think there's a whole area there where we could gain a great deal. I think too, let me say that I think it's in the interest of South Africa for another reason to adopt the idea of the International Anti-Corruption Court, and that is, I think it could well be one of the aspects that is looked at by the international authorities who are responsible for putting us on the grey listing group.
Yeah, no, I'm glad you said that, because I also wanted to just ask. Obviously, it would be assumed that our international relations and our global investment rankings would probably rise and improve if we got behind this. I just wanted to ask, or maybe just clarify on the last question. From what you've said, it seems that the court would provide that sort of investigative capacity as well. So it wouldn't just be adjudicating a dispute, but there would also be the capacity to run investigations and to see the case to its end. Okay. Yeah. Okay. Well, I think there's a long question. Justice Goldstone, can I take one last one, or do you think you're going to get hit by load shedding? Okay. Just one more. Says there's something I've been wondering about that's relevant here. the current international world seems to be divided into two at the moment. One, on the one side, those countries that support the traditional international system, and on the other side are countries that seem to sometimes be defying it. For instance, China says that they did not participate in the design of the international order, and so they don't accept some parts of it. Would it not help if a process of updating the international order to accommodate countries that only came to independence or existence in the last few decades is set in motion? Would it not also assist the establishment of such a court to be more acceptable?
Well, I think, it seems to me, Kristen, that it's from a practical point of view, we must try and get as many states involved in an international anti-corruption court as possible. And again, I stress the aspect of self-interest. It may well one day become in China's interest. I was reading in the paper only today that millions of people in China, Chinese people, are being blacklisted because they're not paying their mortgage bond, they're not paying their credit cards. And I've got no doubt that a lot of Chinese money is being illegally taken out of China. You can be sure. I mean, the number of Chinese tourists around the world over the years. There's clearly there's one thing I've learned in my experience, and I've been involved in looking at corruption for the United Nations in the well-known Iraq Oil for Food program of corruption. And there is no country in the world, literally, that isn't a victim of corruption. There's no country in the world where there isn't corruption on a very grand scale, and therefore I content myself, as far as the IACC is concerned, in the knowledge that it's really in the interest of all countries to have such a court operating, subject to the law that's agreed upon by those countries joining in.
For sure, and I think for me, just bringing it back to what you said at the beginning, that money lost to illicit financial flows could feed the hungry of the world 80 times over. That's incredibly startling, and I think given the statistics around Africa and money flowing out of the continent, knowing how much is needed to be fed back actually into the continent is more it's enough to convince someone like me. But I think this is the reason why we had this discussion, to put forward and to hear what the IACC is going to look like, and then also to have the questions that we did have, which are filled with doubt and anxiety, and I assume that countries the world over would have similar doubts. Right. But I think we'll end it there, Justice Goldstone. Just to say thank you so much for contributing to this discussion and for outlining so poignantly what the IACC is intended to look like. And I think we look forward to reading about developments in this area, and just look forward to the process unfolding. And I think it's been incredibly enlightening. So thank you so much for sharing with us.
Good. Thank you very much for having me, and thank you for the questions.
Your lighting is still good. We can see you well.
Good. No, it's fine.
Okay. Thank you so much.
Okay,
and
pleasure.
Thank you to everyone who participated. Have a lovely evening.
Thanks, you too. Bye.
Bye-bye.
And thank you all for listening. Bye.
Bye.